Hi, I'm attorney Renee Osipov with Chelle Law, and we assist dentists with employment agreement issues. Today, I'm answering the question, how many locations should a dental non-compete apply to? So before we get into this specific question, let's back up and talk about what is a non-compete clause. Non-compete clauses are standard in just about any dental employment agreement. Even if you're with private practice or a big corporate practice, there's normally always a non-compete. Now, they might go by a couple different names. So it might specifically say non-compete clause. However, it may say restrictive covenant, which just is a promise not to do something. And then it will list the language that would normally be included in a non-compete clause. And sometimes they don't go by any name. They kind of sneak them in there. So you want to make sure that you read over your employment agreement very carefully, because this could really affect your career after your employment ends with whatever practice that you are signing this agreement with. So let's talk about what is in a typical non-compete clause. So normally there are two components to a non-compete clause. One, the period of time that you're restricted from competing. Now, this can typically be from anywhere from 6 months to 2 years. It's rare that it goes over 2, and I would say the majority of the time I see is around 2 years. Sometimes I can get negotiated down to 1 year, but again, normally I would say the average is anywhere from 6 months to 2 years. So now we have our time frame. So this is how long you're restricted from competing after your employment agreement is terminated. Might be terminated by you, might be terminated by the practice, but your employment has come to an end, and this is when the non-compete clause would then become valid. Okay, so we've got the time for how long. The other component of it is where. Where are you restricted from? Again, this kind of really depends on where you are in the country. So if you're in New York, you're not going to use miles. Typically, in New York City, non-compete clause will stay city blocks, because if you even go 1 mile, you're going to knock out most of the city. So that's not really reasonable. If you're in a rural area, so very small town, sometimes the non-compete clauses, the miles can go anywhere from 10 to 20 miles. And then if you're in just a regular city setting, like such as Phoenix, the mileage normally goes a little less. So it can be anywhere from 3 to 5, 10. I would say anything over 10 would likely be unreasonable. That would be something that you would want to negotiate down. So we have our time frame. So you have to know how long you're restricted, and then you need to know where you're restricted from. And this is where we're talking about the specific questions today. How many locations should that restricted area apply to? So this is easy if it's a private practice. They only have one location. You're restricted from, let's say, 3 miles from the practice. We'll use as an example. Well, that's great. You know that you cannot practice dentistry within 3 miles of that location. That's easy. But likely they get a little bit more complicated than that. So let's say it's a private practice or a small corporation and they have multiple locations. Sometimes they'll say, the language that they'll use in the non-compete is you're restricted, that mileage, so 3 miles, from any location that you provide services for practice ABC. So the complicated part about here is when it uses the word any location you provide services for, if you cover a dentist who's on vacation, so you work a couple of days, maybe a week, at another location for the practice, well, now that 3 mile restriction now applies to that second location. So you want to be careful when you're reading your employment agreement. If you see anything that says any location that you provide services at, that should kind of be a red flag for you to really think about it. So we talked about that, the language where they say any location you provide services for. A green flag would be if you see where they say you're only restricted, the 3-mile restriction, from your primary place that you provide services for. This is a little bit more clear. So if you only typically work at one location, you provide 90% of your services at one location. That's your primary location, and therefore you're only restricted 3 miles from one location. That's great. It's easy to follow, it won't change in the future, and you'll know if you're in violation of it. Another sort of red flag that you want to be aware of, if it is a practice that has multiple locations or a corporation that has many locations, sometimes in employment agreements, it will have language that states you're restricted from any location that a corporation ABC owns. So this gets a little tricky. Again, let me restate this. So if it says any location from corporation or practice ABC. So this gets tricky. So you could be restricted, that 3-mile restriction could attach to hundreds of locations that you've never even been to. So this is difficult because this can knock out a huge region. Let's use Phoenix for an example. It could knock out the whole city if they have multiple locations around the city, even if you're not providing services for them. So you want to make sure you're reading the contract very carefully. And also another thing about this, if the practice is expanding in the future, they could add 5, 10 locations, and you're going to have that 3-mile radius attached to any of those locations too. So just to be more concise here, you really want to know where you are going to be providing services for. That's very important. It should be outlined in your employment agreement so that you know. Then the non-compete clause should only attach to your location, your primary location. You should really advocate for this, because if it's from any location you provide services for, you need to remember that in the future, that if you cover for a dentist who's on vacation, your non-compete clause now attaches to that office that you only worked for a week, and it's going to knock out that area. The other thing, again, is if it says any location that the corporation or practice owns, that's a big red flag too, because you don't know if they're expanding in the future, how many locations. It's hard to tell when you sign the agreement. You don't know what you're actually restricted from. So in conclusion, how many locations? In my opinion, it should really be only from your primary location where you are providing services for, where you have built up a patient base. You've built relationships with your patients. You just want to be stopped from going across the street and then those patients going there. That would be considered competing. If you have any additional questions on this, or you'd like for us to review your contracts, specifically your non-compete, please reach out to us. We are Chelle Law, CHELLE law.com. You can check out our website. All of our contact information's on there. There'll be additional information about non-compete clauses, what's reasonable, what's not reasonable, what you should ask for, all that good stuff. Thank you.